So why would you choose an attorney over a VSO to pursue your VA appeal? The main question that most veterans ask is, attorney is going to cost money, and a VSO, a veteran service officer, is typically not going to cost them anything. But as the old adage goes, you get what you pay for. There are many advantages to going with an attorney for your VA appeal. After the initial stage of your VA claim, the first claim, a new claim, if you get a denial and you want to go down the appeals route, that is where an attorney steps in. The first advantage that you have with hiring an attorney for your VA claim or your VA appeal is that we do have skin in the game, right? That is actually an advantage as opposed to a VSO who may not be getting paid on this particular claim. Most attorneys get paid on a contingency fee, meaning we don't get paid unless you get paid. We have motivation, we have skin in the game to get you your maximum benefits from the VA, the highest rating we can get as far back as possible, as far back as it can go. Typically, veteran service officers do not have that. They get paid, and it's not based on whatever the result is that you get from your particular appeal. Another advantage is that here at VA Disability Group, we stick with the claim no matter where it goes. We can work with the claim at the regional office under a higher level review or a supplemental claim. We can work with the claim at the Board of Veterans Appeals in front of a veterans law judge, an administrative law judge. We can also take the claim up to the federal court level, to the Court of Appeals for Veterans Claims, which is a federal appeals court. So we can stay with the claim the entire time. This can take years to go all the way up and come back. We know the claim, we know what we want to do, we know the path that we want to take, the plan of action, and we don't have to refer the claim out to somebody else to take it and then bring it back. It can stay here with us the entire time. Another advantage to going with an attorney, specifically here at VA Disability Group, is we do evidence development. VA claims are heavily based on medical evidence and medical opinions. We take an active role in aiding and helping the veteran develop these medical opinions and medical evidence. And this serves as expert witness testimony for your claims in front of either the VA, the Veterans Law Judge, or the Court of Appeals for Veterans Claims at the federal level. Typically, service officers will not take an active role in the development of the evidence. They will ask you to go out and get it and procure. They will tell you what to get, but they won't help you in the actual development of the evidence. With that being said, as I stated, medical evidence and medical opinions are very important for VA appeals and VA claims. The VA requires adequate and probative medical opinions in order to make a favorable grant. Adequate and probative medical opinions are not as simple as a doctor writing a sentence saying that the condition is more likely than not service-connected. It needs to be fully articulated with sound medical reasoning that is specific to that veteran and reach a medical conclusion that is supported and cited by medical evidence such as medical journal articles or medical studies. At VA Disability Group, we work with the veteran to ensure that the medical opinions that we help procure and we submit meet that standard of a probative and adequate medical opinion for VA purposes. So the VA doesn't just write it off and say, thank you for this medical opinion, it doesn't meet our standard and we won't consider it, we won't find it probative. Another advantage to going with an attorney, especially here again at VA Disability Group, is that we take an active interest in the entirety of your claim. We get access to your claim electronically through the Veterans Benefit Management System, and we review everything from your most recent appeals all the way back to the very first appeal that you did. And if we have any recommendations regarding reopening claims, claims for increase, clear and unmistakable errors, all these are going to be part of the thorough investigation and recommendation that we give the veteran when they become a client. Most VSOs will only handle the exact appeal right in front of them. They won't give you a holistic view of your claim and how to get you to that 100% or as high as you can go as quickly as possible, or what the best route is and how far back it can go as well. Obviously, with the attorney, we stay up to date on all the laws, all the case law, and we do this every day with hundreds of claims. And so the The other advantage is that you get the experience of someone who knows the entirety of the system, who knows the entirety of the appeal system. A lot of the early stages of an appeal process are set up for possible appeals to either the board or the Court of Appeals for Veterans Claims. As many of you know, many times at the regional office, either on a higher level review or a supplemental claim, they don't consider the right evidence, or they just continue the denial. Part of what we do here at VA Disability Group is we make sure that the evidence and the testimony is in the record as early as possible, and that it meets the correct standards, so that when we take it before a judge or we have to go to the federal court, it's all in place. We're not lacking the evidence. We can point to it and say this is correct. It's not only planning for the current appeal, it's planning for the future appeals and any contingency that comes down the road with that particular appeal. So with the adequate medical opinions, one of the things that's popular that the VA likes to reject opinions for is they didn't review the C file or the claims file, or they didn't review the service members' service records and medical treatment records. This is important. It is not the only thing. As I stated previously, the medical reasoning and conclusion specific to the veteran is more important, but the relevant documents in the service record must be spoken to, and they must be reviewed. And this is another thing that we do, is we make sure that the medical professionals have access to the relevant treatment records and relevant service records for the specific disability that is being appealed, and speak to them and make sure that we cover as many contingencies as possible, or as many incidents as possible that are in the service record.